If you own trademarks in China or manage them for clients, one of your legal deadlines is about to shrink from 3 months to 2. At the same time, unused registrations may face more active scrutiny, and filing too broadly can create problems of its own. All of this starts on January 1st, 2027. That is when China's newly revised trademark law takes effect. But I would not look at this as another list of legal changes, because the most important shift is not simply that China is becoming stricter, it is that timing now matters at more stages of the trademark lifecycle. For years, foreign companies entering China have heard one basic rule: file early. That advice is still right. China is not moving away from timing. It is adding more clocks. 1 before you file, 1 while competing applications are being published, and 1 after registration. 3 clocks, 3 different risks. And together, they change how foreign companies and the lawyers advising them should manage a China trademark portfolio. Clock 1. Before you file, China has not made early filing less important. Earlier identical or similar trademarks can still block later applications, so waiting until launch day to think about China trademark protection is still dangerous. But the revised law adds another question: what are you filing and why? For years, one response to China trademark risk has been to file broadly. More classes, more variations, more defensive protection. There can still be legitimate commercial reasons for doing that. The revised law does not simply ban defensive registration. What it targets are applications made without an intention to use the mark that clearly exceed normal business needs. That creates an important distinction for anyone designing a China portfolio. The question is no longer only, how broadly can we protect the brand? It is also, can the filing strategy be commercially justified? Protecting core products makes sense, so can realistic expansion, a Chinese language brand, or commercially related categories. But filing large numbers of unrelated trademarks with no realistic connection to the business is something very different. So the strategy is not file less. It is file with a reason. Clock 2, while other applications are being published. Now comes the clock that may have the most immediate practical impact. Under the current system, when a China trademark application passes examination and is preliminarily published, the opposition period is generally 3 months. Under the revised law, 2 months, 1 month disappears. That is a 1/3 reduction in the window. And for international trademark work, that matters more than it sounds. Imagine a conflicting application appears in China. First, someone has to detect it. Chinese counsel may review it. International counsel may become involved. The brand owner has to decide whether the filing actually matters. Evidence may need to be collected. The business team may need to approve the action. Instructions then have to come back. The legal deadline changed. #your internal approval chain probably did not. That is where the real pressure appears. 3 months can disappear quickly. 2 months disappears faster. Missing the opposition window does not necessarily eliminate every later legal remedy. But an issue that might have been challenged during the application stage can become a longer and potentially more expensive problem later. So the real change is not simply 3 months becomes 2. The business lesson is you have less time to notice the problem and less time to make a decision. That makes trademark monitoring more important, because the value of monitoring is not simply finding a conflicting application, it is finding it early enough to react. For overseas counsel managing international portfolios, that may also mean reviewing something beyond the watch service itself. How quickly can a China alert become an approved client instruction? Clock 3, after registration. Then comes the third clock. This one starts after the certificate arrives. China already has a 3-year non-use cancellation system. If a registered trademark has not been used for 3 consecutive years without a valid reason, another party can seek cancellation. That is not new. What changes under the revised law is that the trademark authority can also initiate cancellation where the statutory conditions are met. The details of how that authority will be exercised still need implementing rules. But the direction matters. A registration certificate is not the end of trademark management. Imagine a foreign company registered its China trademark 5 years ago. The certificate exists. The renewal date is still years away. Internally, the trademark may look done. But commercially, what happened? Did the company launch? Is the mark actually being used? And if that registration matters to the business, can the company document that use? Invoices, packaging, sales records, advertising, e-commerce listings, commercial records connecting the trademark to real business activity. Because if use becomes an issue, the registration certificate itself does not prove commercial use. And from a portfolio management perspective, that leads to a more important question. Why wait for a non-use challenge before asking whether the evidence exists? Use evidence should not become relevant only when a dispute begins. For important registrations, it should already be part of portfolio management. So after registration, the question is not only, which trademarks do we own? It is, which trademarks do our clients actually depend on, and what supports those registrations in practice? Now put the 3 clocks together. Before filing, can the protection strategy be commercially justified? During publication, are conflicting applications being detected and escalated quickly enough? After registration, are important registrations being used, documented, and actively managed? This is why I think the most useful way to understand the 2026 revision is not China is making trademark registration harder. That is too simple. The bigger shift is this. China is not moving away from timing. It is adding more clocks. The first clock asks whether the brand was protected early enough and intelligently enough. The second asks whether a problem was detected and acted on fast enough. The third asks what happened after registration. In other words, #China trademark strategy no longer ends at the filing date. It has to follow the life of the business. Now suppose you manage a foreign company's China trademark portfolio. Before January 1st, 2027, I would not simply ask, does the client have China trademarks? I would ask 3 better questions. First, does the portfolio still match the business the client is actually building in China? Second, are new applications being monitored and escalated quickly enough for a 2-month opposition period? Third, for the registrations that really matter, do we understand their use status and the evidence behind them? Those 3 questions tell you far more than simply counting certificates. And if you are the brand owner rather than the lawyer, these are exactly the questions you should be asking your counsel. For overseas lawyers, there is a broader service implication here. A China trademark instruction should not automatically end when the registration certificate arrives. Because the client's business keeps changing, products change, Chinese language names emerge, some registrations become more valuable, others become less relevant, and new third-party applications continue to appear. That means China trademark work can increasingly look less like a single filing instruction and more like an ongoing portfolio management process. Search, file, monitor, react, register, use, maintain. The portfolio has to move with the business. So if I had to summarize the revised law in one sentence, it would be this. File early is still right. File early and forget it is not. Early registration still matters. But now there are more moments where timing matters. File with a reason. Watch fast enough to react. Use and manage what matters. The revised trademark law takes effect on January 1st, 2027. So whether you are a foreign brand owner or the lawyer managing its China portfolio, the question is not only what changed in China's trademark law, the better question is what in our China trademark strategy needs to change before the law does.